Hello, it's me here to help you get an A in your law degree. In this video, we look at an amazing case that every law student must know. Williams versus Roffey Brothers, and the big question which is, does the doctrine of consideration still require something new? Let's jump right in. In 1990, a dispute came before the English Court of Appeal that would change the way students and lawyers alike understand consideration. At the time, there was a building shortage in London, so much so that a shortage of carpenters was driving up prices. Roffey Bros, a building contractor, had agreed to renovate a block of flats in the city. They now needed a carpenter to do some intricate work, so they asked Mr. Williams, who had a reputation for quality, to provide a quote. After inspecting the site, Williams gave them a price for the work. Roffey Brothers accepted, and they made a contract. The contract provided that Williams would be paid £550 when he finished the carpentry work, and he would have 13 weeks to complete it. However, Williams soon realized that the price was far lower than he originally thought it would be. He had based his initial quote on a price for timber that had since increased. On top of that, he was struggling financially, and he worried that he would not be able to finish the job on time and still make a profit. Roffey Brothers, on the other hand, were having problems of their own. Their main contract with the building owners stipulated that they complete the renovation by a specific date. If they failed to meet the deadline, they would have to pay a penalty of £200 for every day that they were late. With the date looming, Roffey Brothers approached Williams and told him that they needed him to finish on schedule. In return, they promised to pay him an extra £10,000 on top of the original $550. Williams agreed and continued working. But when Roffey Brothers refused to pay the extra money at the end, he took them to court. The trial judge ruled that Williams could not enforce the promise because there was no consideration. Williams appealed. So, what's the problem? Williams argued that the new promise to pay £10,000 was supported by good consideration. He pointed out that he had performed his contract early, and this performance had benefited Roffey Brothers. They should have to pay up. Roffey Brothers, on the other hand, argued that Williams had not provided any new consideration. He was simply doing what he had already promised under the contract, and therefore could not enforce the promise for extra payment. So, what's the rule? For centuries, the common law stated that consideration had to be something new. Performing an existing contractual duty did not count. In the past, courts strictly applied this rule. In Stilk versus IRAC, decided in 1809, sailors in the merchant navy were hired for a voyage from London to the East Indies and back. There was a shortage of sailors at the time. Halfway through the contract, the captain promised the crew extra payment if they would work harder and complete the voyage quickly. Some of the sailors refused until the captain threatened to throw them all in the sea. If they didn't agree, they did as they were told and sued for the extra payment. The court dismissed their claim. The judge, Lord Ellenborough, said that the sailors were already contracted to do everything that was required of them. Therefore, they could not demand extra payment for doing what they were already supposed to do. That is the old rule. However, times were changing, and the rigid old rule was challenged. In this case, The Court of Appeal took a different approach. Lord Justice Glidewell said that the old rule was a doctrine of technicality. Courts should focus on the substance of the agreement and uphold promises that were intended to be binding and that had been performed. Glidewell considered that Roffey Brothers gained a clear practical benefit when they agreed to pay Williams more. First, they avoided the risk of total loss by ensuring that the work would be done on time. Second, they saved potential penalty costs under their main contract. And third, they ensured that their overall project would continue to move forward without delay. This practical benefit was real and valuable, even though Williams was only doing what he was already supposed to do. Glidewell concluded that this practical benefit was sufficient to support the promise to pay extra. Therefore, Williams should be paid the full amount. Lord Justice Peter Gibson agreed with Glidewell. He said that the old rule was outdated and did not apply in commercial contracts. He felt that courts had to acknowledge that in business, practical benefits could be just as valuable as traditional legal promises. So what did the court conclude? The court decided that Williams should be paid the extra £10,000. The court acknowledged that in commercial situations, practical benefits could be enough to support a promise to pay extra. The decision was controversial, but it made sense. The old rule was outdated and did not fit with modern commercial realities. Business people often rely on promises that are not formalized in writing, and courts should enforce them as long as they are fair and reasonable. And this case was influential because it offered a flexible solution. Instead of focusing on technicalities, courts should consider the substance of the agreement and the intentions of the parties. That was a summary of Williams versus Roffey Brothers. If you want more interesting and complex cases summarized, subscribe and comment below which case you want to see next. Also check out the playlist on the end screen for more contract law cases explained with the IRAC method. And don't forget to share this video with your classmates so you can revise together.